Right, so as you can see, this is the topic of bail and it's being taught via video. At any point during the video, if you feel like you need to stop it and go back, if I've gone through something a little bit fast, or you just need time to write something down, then feel free to do so. So it's governed by the Bail Act of 1976, but first of all we need to decide what bail actually is. So as you can see there's a definition, and it says a person can be released from bail from the point of arrest up until when you go to court. It's something that's called, if you can fit it in these two little gaps here that you can see where I'm pointing the cursor, a pre-trial matter. So pre goes there and trial goes there. If you add them into your booklet, please, it's known as a pre-trial matter. The reason it's called this then is it's something we decide before the trial, which means beforehand. Okay, so it's where the police or the courts will decide whether we should allow you to be free until your case. Depending on the crime you've committed and depending on the wait for the criminal trials, it could be a couple of months. So let's say you've committed a crime in January and you've been arrested and processed, getting ready to go to court. It could actually be April or May before you end up in court. So that big time period, that's what we call the decision on making bail. Do we let you remain at liberty? Do we let you stay free, or do we keep you on remand? That's the question. As it says there then, if we do grant it, it allows you to remain at liberty. What that phrase means is it allows you to remain free, so you can go home, etc. Can you just draw an arrow from there then and write at the side freedom, because that's what it means. It allows you to be free until the next point. Right, so as you can see there then, there's a heading that says the general right to bail. So there is an automatic right under the Bail Act, particularly section 4 there, that says that we presume that every single person should be given bail. Everyone should be allowed free from being arrested up until the next point in their case. Now, that presumption is there irrespective of what crime. So it could be a petty theft, you've stolen a Mars bar because you're a bit hungry, or it could be a full-blown armed robbery or murder. But that section states that bail is automatically presumed. So the reason why we presume everybody deserves to be on bail is because under our English legal system, there's something called the presumption of innocence. And what that means is that we presume every single person to be innocent unless we can prove them guilty at trial. So actually the system is in your favour. We presume that you've not done it and that you are innocent, and then when the court case comes, that's then for the prosecution to try and use evidence and find out that you are guilty. But that's the reason why we automatically presume everybody is innocent. So it does say why there, so if you can just fill in this gap underneath then for me, please. The presumption of innocence theory. The presumption of innocence theory. And then if you just put in brackets for me, everyone is presumed innocent unless they are proven guilty in court. Everyone is presumed innocent unless they are proven guilty in court. So that's your definition of bail. It's something that we look at before the trial to see whether we should let you remain free or whether we should keep you in prison, also known as on remand, and everybody normally has the general right to bail. Right, so before the police or the courts will decide whether bail is granted or not, there are certain things that we have to take into account, certain things that will have to be examined beforehand. We won't just automatically let you free. So as you can see here from the first box, there's certain factors that we need to look at, certain things that will help us decide whether we should let you free or not. As you can see from the bold letters here then, it spells out the word near. If that's going to help you using this acronym, then feel free to do so, but don't panic if that's not the way that you will remember it. As long as you have all 4 of these, any order that you want to, it will be completely fine and fully creditable. So one of the first things then that the police or the magistrates court will look at is the nature and seriousness of your crime. Basically, if you want to add that here next to the dash, what we look at then is how you've committed the crime. So what is the nature of it, what have you done, have you used a weapon, etc. And how serious the crime is. Is it a petty theft or is it a full armed robbery? So just to reiterate then, we're looking at what you've done and how you've done it. And if it is something that's minor and it's done in a minor way, that will be fine. Bail will be available. Whereas if it's a very, very serious crime and you've used a lot of weapons or the nature is very serious, then potentially we will have to refuse bail. So just add next to your dash there for me please what we mean by nature and seriousness. The next thing that we look at then, the E from near, is the evidence and likely sentence. What this means then is we look at the evidence that's against you. Is it strong evidence? Is it weak evidence? Is it from one witness, 3 witnesses, etc., CCTV, and the likely sentence that we would be giving you. So if it was a very short custodial sentence, or it wasn't a custodial sentence, that means prison, so if it was something where we might just make you pay a fine, etc., then it would be more likely that we would grant you bail until the court case. Whereas if we had really, really strong evidence against you and the likelihood is that it was going to be a long prison term, we might have to rethink about whether we would grant you bail or not. The third thing we look at then is called the antecedents report. This is a report of your criminal records, basically. So it will be very much similar to your criminal record. We'll have a look at any crimes you've committed in the past and how they've been committed. If obviously your criminal record is clean, there's nothing there, this could be your first time offence, then it is going to be likely that we will grant you bail. Whereas if your antecedents report has a lot of crimes on, or maybe there's a few but they've got worse gradually, then it will be less likely that we would grant bail. So again, add at the side for me please the definition of what an antecedents report is. It's your criminal record, and the more crimes, the less likelihood is that you'll be given bail. Finally then, your record. Now this is different to your criminal record because in terms of the word record, what we mean here is we actually look at your bail record. We look to see if you've been given bail before. The reason why is if you've been given bail and you've not followed what we've said, then that's not going to go in your favour. Whereas if you have given bail and you've complied with everything before, you've done what we've asked you to do, you've come in at set times, you've gone to the station when it's been asked, then it's more likely to go in your favour. So these 4 are the factors that we look at, things that we take into account before we decide whether to give you bail and let you free, or whether to keep you on remand, which means to keep you in custody. Right, so we've already looked at factors that we might need to take into account before bail is given. We also need to look at potential reasons that we might want to refuse bail. So even though everyone has the automatic right, technically, under Section 4, to be granted bail until the next stage in their case, we may have to look at situations where we potentially need to refuse bail. As you can see there from the box then, this one spells out the word OIPS. Again, if it helps you, feel free to use it. If not, you might want to think of your own acronym or way to remember it. The first reason that we might want to refuse bail then is the word offence. What we mean by this is if we're scared that the potential defendant will commit another crime whilst on bail, then we will refuse it. Now, a certain amount of crimes are actually committed whilst on bail, so we are trying to cut the crime rate down. But let's just say, for an example, a defendant has committed a robbery. If we feel that they are going to commit another further crime, potentially another robbery, while they're released on bail, we will make sure that we refuse it and we keep them on remand. So just at the side of offence then, there's a gap next to the dash. if you can just add, just here where I've got the mouse, if you can add your reasoning here, then what we mean by offence, that if we are fearful that the defendant will commit another offence whilst on bail, then bail will be refused. Right, the next reason why we may want to refuse bail then, as you can see, is the word interference. What we mean by this is we could potentially be scared that the defendant might want to interfere with witnesses or any evidence that we might have against them already. So if we're scared that we'll release them on bail and they'll go straight to a witness's house, knock on the door, try and bribe them or threaten them to not give evidence, etc., then we will make sure we refuse bail. Similarly, if we are scared that any evidence that we have got, maybe it be CCTV or any tapes, etc., that they may try and destroy that as well. So just as you've done before then, next to interference, just here, if you can make sure you add in there for me, if we fear that the defendant will interfere with witnesses or any evidence, bail will be refused. As you can see there then, the third reason why we might want to refuse bail is the word protection. Now, we're not actually just talking about protection in terms of society. We might actually think that the defendant himself or herself may need protecting as well, depending on the crime. So if we think that the defendant needs protecting, we think that a particular victim might need protecting, or just society as a whole, depending on the crime, we will make sure that we refuse bail and keep the defendant on remand. So if you add into there for me please, protection. So what we mean by this is if we want to protect the victim, society or the defendant, we will make sure that we refuse bail. Finally then, the final fourth reason why we might want to refuse bail to a person is surrender. So we might be scared that the defendant, if we do let him out on bail, and he does have a considerable amount of time till his court date, like potentially 2 months, 3 months, we might be scared that he might not surrender to that, so he might not come back to court. He could flee the country, he could go into hiding. If we do think that that's going to happen, again we will refuse it because we want to make sure that he does attend his court date. So finally, if you add in there for me please, in terms of surrender, what we mean by that is if we are fearful that the defendant will not surrender to bail, he will not come back to court, we will refuse bail. So just to recap what we've done so far then, so from the top we defined bail, gave a definition, it's known as a pre-trial matter, something we look at before the next stage in your case to see whether we think you should be allowed to remain at freedom or whether we should keep you in prison. We then have the fact that everyone normally has the general right to bail, everyone is presumed innocent unless proven otherwise. But before we make that very, very important decision, there's two things that we need to look at really. Number one, any factors, so how the crime's being committed, what evidence we have against you, would you be sentenced to a very long time in prison, what's your criminal record like, etc, etc. If you've been given bail before, have you stuck to it? And we also look at any reasons we might need to refuse it, because if you tick one of those boxes, then unfortunately it's more likely that we're going to refuse bail. Right, so we've already talked about what bail is and the certain factors we need to look at and any reasons why we might need to refuse bail. They're really important in terms of getting your marks. The next section then that you'll write about is the sort of conditions that can be attached. Okay, so we do know that in most cases bail is granted. At the top of the page, it's in italics, it tells you the fact that if you're charged with a crime that wouldn't involve prison, the only reason we'll refuse bail is if you've been given it before and you've not followed it, or that there's evidence you won't follow it again. So realistically, most people are going to get granted bail. The types of bail that they can have then depends upon whether they're set conditional bail or unconditional bail. Unconditional bail, you've got a gap there, so if you can write this next to it for me, please. Unconditional bail is where you are granted bail and you are let free until the next point in your case. And that's basically it, to be honest. There's nothing you have to abide by. You're just told that you're free until the next point in your case. As long as you turn up at that court on that day at the correct time, you can do what you want, basically. Okay? Whereas conditional bail means that you are granted bail, but you do have requirements that you have to follow. You do have set conditions that we do make you follow. Okay? Now, the court can set far more conditions than the police can. Because magistrates' courts have a little bit more power, they are able to set a few more conditions than the police can. So as you can see there, for court conditions there's 5 separate ones. For police, they can only set 3 of those 5, which I'll come to in a second. So these 5 conditions that you need to fill in then, it starts with the word curfew, okay? Well, a curfew, it's where you'll be allowed out on bail, but you have to be in at a set time. So a little bit like you could potentially have now, or you might have had when you maybe just started high school, for example. You're given a curfew, you need to be home at a set time, something like, I don't know, 9 or 10 p.m. Now this is often accompanied with an electronic tag. So we'll often tag you if we give you a curfew, just to make sure that you are in at that set period of time that you're meant to be, and it'll tell us if you breach that. Can you make sure you fill in at the side for me, please, then, what a curfew is? So it's making sure that you're at home at a set time. Often we include a tag as well. Right, reports then. This is where we make your report to the police station. Okay, now we can make your report once a week, twice a week, maybe even more, I guess, if we think that you're quite a risk, but we'll make your report on a regular basis so that we know that you are still in the country. Okay, can you add that for me then, please? So you'll be told to report to your local police station on a regular basis, and it is usually maybe once or twice a week. Right, your third condition we can set you then is reside, and what we mean here is that we'll make you live at a certain place. So it could be your family home, but if the crime that you've committed is involving family, then it could be that we make you reside at such like a bail hostel. Bail hostels are buildings that we have around the country that people on bail that don't have anywhere to go are allowed to stay, so we know that you're safe and we also know where you are. So again, fill in reside for me, please. That will make you reside either at home or a bail hostel, just so we can keep checks on you, really. Right, your fourth condition you've got there then is called surrender. What we're meaning there is that we'll make you surrender your passport. It is always risky granting bail, because there is always, even if it's a minute chance, there's always a chance that somebody might not come back for the court date. Then we have to try and search you. So what we can do, if we do think you're a risk at fleeing, let's say you might have family abroad, or you might have already been planning to go somewhere, we'll make you surrender your passport. That then stops you from leaving the country, really. So it means that we know pretty much that you are still in the UK, and obviously if we're making you reside, for example, or report to the station, we know that you're here. But that's what surrender is. It's making you give up your passport, so we know that you are still in the country. So if you add that in for me, please. Right, your final condition then that the court's allowed to set is surety. Now, if you've watched programmes on telly, you've probably heard of this before, or you kind of have an idea what it is, you just didn't know it was called surety. This is where we'll make a third party give some money. Now, this differs here to what it does in the US. So if you've watched anything like Crime Scene Investigation or any police programs that are in America, what they do is they make somebody give some money up first. So you might be in prison, you might want to be bailed out, and they might say, right, you can have bail, but it's £1 million. So somebody would automatically have to pay for you to be able to be let out. Now, it's not like that in the UK. It is still money, but we only make somebody pay if you breach bail. So we would automatically let you out, but we would say if you fail to abide by this and you don't come back, we will make this third party pay X amount of pounds, 10,000, 20,000, etc. So surety is all about money, but we will only make somebody else pay if you breach. Now, obviously, if you're a single parent, for example, we can't make your child pay. It needs to be a third party that is eligible to pay. So it could be a partner, or it could be a close friend or a relative that's willing to put up that money if you aren't going to come back. Right, so out of all those 5 conditions that you've got there, the police are only able to set 3 of them. And if you want to fill them in on the bullet points for me, please. The first one is report. So the police obviously can tell you that they want you to report to the station at a set period of time. Second one is surrender. So they can make you surrender your passport and the police will take that. And finally, surety. So the police can make you not hand over some money, but they can make somebody else hand over some money should you not abide by your conditions. Just fill those in on the bullets, please. Report, surrender, surety. So what's the purpose of imposing conditions then? Well, the reason why we do this, we must think you're a little bit of a risk, otherwise we'd have gone with unconditional. But the reason why we do it is just to make sure that there's more chance of you sticking to bail, so there's more chance of your trial going in your favour, really. The last thing you need is to be breaching bail, because then as soon as you get into court, that's going to come up. But we want to make it better for you. But the main aim is to make sure that you do actually return for your court date, because that's our main thing, making sure that anybody that potentially should go to prison does. Right, so we've looked at conditions that can be set by the police or the courts. The next step we need to do is to actually look at the difference between the police granting bail and the magistrates' court granting bail. So as you can see in front of you then, you've got the title Police Power to Grant Bail. So we're looking at when they're at the police station, who is it that decides this element of bail? Well, as you can see from the text in front of you, it's actually the custody officer that decides this. So you know from police powers that the custody officer is the person that is responsible for anyone that is detained in the police station, and is them that decide whether you will be granted bail or not, depending on whether you're charged or not. So you've got 2 boxes here, no for being charged and yes for being charged, and the difference between the two in terms of when bail will be given. So for this top box then, I just need you to fill in here where I've put it on the screen. If you have not been charged, it's the custody officer that has the power to grant bail on the condition that you'll return when we ask. Usually it's because we need to make further inquiries, maybe collect more evidence, for example. So what we'll do is we'll still release you on bail with no charges, but we will ask that you return back when specified. So if you can fill in there for me, please, then. So in the box where it says charged, no, that bail will be granted whilst further inquiries are made. Bail will be granted whilst further inquiries are made, and the suspect must return at a specified date. Right, well, if you have been charged, then what will happen here is the custody officer can decide then to bail you until your court date. As I've said previously, it can be up to a couple of months before you would be in court. So if you have been charged, which is this box here, if you fill in for me, please, the suspect will be bailed to appear at the local magistrate's court on a specific date. Right, so as you can see from the top of the page then, still looking at how the police can give bail, it does say that if they don't surrender, so if the suspect doesn't surrender to bail, they will then be arrested. So it is something that the suspect will be made aware of before they are granted bail. In addition to the other reasons then, that under the Bail Act it does also say that the police can refuse bail if your name and address can't be discovered or they believe to be false. So whilst we are deciding whether to give you bail, looking at those factors or any reasons we might need to refuse it, if, for example, when asked to give you details you say your name is Donald Duck, then clearly that's a bit of an issue, so we could potentially refuse bail. But at least, usually, as you can see there, we're looking at an average of about 84% of suspects are actually granted bail. And if you are refused bail, you are then taken to the magistrate's court at the earliest opportunity, just to see whether that is correct. So even if the police, via the custody officer, turn around and say that you can't be given bail, you will then be taken to the magistrate's court as quick as possible, just to review that, to make sure that the custody officer isn't being a little bit too harsh. We've also got the possibility of court bail then, okay? So it's the magistrate's court that will hold an initial hearing for all crimes, and they have to decide whether they feel you should be given bail or not. If they don't want to give you bail, as you can see here, it's called being on remand. That means you'll just stay in prison. You won't, or stay in custody. You won't actually be allowed out free. Okay. If bail's something that we have to look at later, then we will actually still grant bail, and the judges in the higher courts will have a look. So it isn't always the magistrate's court, but it is the most of the time. Second to last bit of this question then is about appeals. So you might, as a suspect, you might want to appeal on your decision of bail. The custody officer or the magistrate's court might have turned around and said, no, we're not giving you bail. 6 months till your court date, I want you to stay in prison, please. We might have the possibility of an appeal. And there's two ways. There's you as the defence, so this is this first one here, or there's the prosecution, those that work for government. Okay? So if bail is refused, you can make a further application to the magistrates and ask them to listen to it again. But again, if it's refused there, you can appeal up to the Crown Court, the next court up in the hierarchy, and that's when they will make that final decision. So you can have one appeal route to the Crown Court, but you can also go back to the magistrates and ask them to have a look at bail again. However, if it's the prosecution that's appealing, they're doing so because you've been given bail and they don't think you should have been. Okay, so maybe it's a serious crime and they're thinking, hang on a minute, this is murder, why are we letting this person out? So the prosecution can also appeal, okay? Now, they'll appeal against bail and they appeal to the Crown Court. They go directly to the Crown Court, and they do that by following two Acts of Parliament that you've got in front of you. The Bail Amendment Act in 1993 and the Criminal Justice Act in 2003. So under those two Acts of Parliament, the prosecution are able to go to the Crown Court and ask them to review bail and hopefully, in their favour, put you back on remand. Okay? Right, the final section of the question then is any restrictions. So we do know under section 4 you have got the general right to bail. You have got the general right to be free. Okay? Remember this presumption of innocence. We presume you to be innocent unless you're proven guilty. However, there are certain restrictions that we have. So you've got 3 bullet points there with 3 different restrictions, things that might stop you from getting bail. So repeat offenders, drug users and murder. Okay. For repeat offenders then, if you've been charged with serious crimes and you've already been in prison, the likelihood of you being granted bail is minimal, to be fair. You'll only be given it under what we call exceptional exceptional circumstances. So on this gap here next to the dash, can you fill in for me please? If the offender has been charged with a serious crime and they have already served a custodial sentence, bail is only given in exceptional circumstances. So I'll just repeat that again. So if they've been charged with a serious crime and they've already served a custodial sentence, bail will only be given under exceptional circumstances. Now, drugs has been an issue that's been looked at pretty recently, which is why you've got the Criminal Justice Act 2003 in there. It's actually section 19 that covers any potential drug users. So it's restricted here because, well, there's a few things really I need you to fill in. First of all, it's for Class A drugs. So just add in there for me, it's for Class A drugs. And you'll only be given bail for two things. Number one, if you agree to regular testing. So if you agree for us to test you at least a couple of times a week to make sure that you're not still taking the drug, but also bail is only granted if there's no significant risk of you committing another offence. So we do have to make sure you're not quite a large, a significant risk to the populace. Okay? So if you fill in those two reasons for me please. So number one, only if you agree to regular testing. And number two, will only grant you bail if you don't pose a significant risk. The final restriction is murder then, because obviously murder is a very, very serious crime, the most serious crime we have. So if you are charged with murder, it will only be the Crown Court that have the power to decide whether you can have bail or not. And again, touching upon the same reason for repeat offenders, they will only grant you it in exceptional circumstances. So if you just add into this bit at the bottom for me please, it's only the Crown Court that decides, and it's only under exceptional circumstances. Right, so that's your handout on bail. As you'll find, you've now come to the end of the 3 pages. So as you can see, we started off with defining what bail is, and that you've got the normal right under section 4 to be granted bail. There's 4 particular things we'll look at, we'll take into account, 4 factors that we'll have a look at and see what your crime relates to. And then also any reasons that we might need to refuse it. So if there's any reason that you fall into there, potentially it'll be refused. You've also got any conditions that can be set via the police or the court. So we'll look at all 5 there, and we talked about the fact that the reason that we impose conditions is to make sure that people abide by bail. We then finalised in terms of who decides bail for the police, and then the magistrates court, what power they have. And then finally, as we've just finished off, your appeals and any restrictions that we have. So who can appeal and how you do it, and what restrictions we have for certain offenders and certain crimes. Please make sure then that you stop the video or rewind and listen to it again if you need any guidance. The whole point of this flipped learning is that you can stop and start whenever you need to in order to be able to remember the handout and understand how you would structure your answer on bail. Okay, so good luck, and if there's anything that you're not too sure of, please give me an email.